Hello, good morning everyone. I am Atul Chaudhary, Assistant Professor, IIMT College of Law, Greater Noida. And for topic of our today's lecture is legal aid in India. Inability to consent or to be represented by a lawyer may amount to the same thing as being deprived of the security of law. Rawls' first principle of justice is that each person is to have an equal right to the most extensive total system of equal basic liberties compatible with the similar system of liberties for all. Legal aid is the method adopted to ensure that no one is debarred from professional advice and help because of lack of funds. Thus, the provision of legal aid to the poor are based on humanitarian considerations, and the main aim of these provisions is to help the poverty-stricken people who are socially and economically backward. Lord Denning, legal aid is a system of government funding for those who cannot afford to pay for advice, assistance, and representation. The greatest revolution in the law since post Second World War has been the evolution of the mechanism of the system of legal aid. It means that in many cases, the lawyer's fees and expenses are paid for by the state and not by the party concerned. It is subject to such importance that I venture to look at the law about cost as it was as such, it is as it should be. Encyclopedia Britannica defines legal aid as which is acquired by usage and court decisions, a specific meaning of giving to person of limited means grant or for nominal fees, advice or counsel to represent them in court in civil and criminal matters. Concept of legal aid in international instruments. It is vividly expressed in Universal Declaration of Human Rights 1948 that all are equal before the law and are entitled without any discrimination to equal protection of the law. Beside this, various international documents have also been framed for protection of these rights which imply the concept of legal aid. Universal Declaration of Human Rights 1948. Under the provision of Universal Declaration of Human Rights 1948, everyone has the right to an effective remedy by the competent national tribunals or acts violating the fundamental rights granted him by constitution or by law, and everyone is entitled to full equality to a fair and public hearing by an independent and impartial tribunal in the declaration of his rights and obligation and any criminal charges against him. International Covenant on Civil and Political Rights 1966. According to the provision of International Covenant on Civil and Political Rights 1966, all persons shall be equal before the court and tribunals and in the determining of any criminal charge against him. Everyone shall be entitled to be tried in his presence and to defend himself in person or through legal assistance of his own choosing, to be informed if he does not have legal assistance of his right, and to have legal assistance assigned to him in any case where the interest of the justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it. Constitutional provisions relating to legal aid. Article 21. Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. Article 39A. Equal justice and free legal aid. The state shall ensure that the operation of legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizens by reason of economic or other disabilities. Article 21 is the fundamental rights conferred under Part 3 of the Constitution, whereas Article 39A is one of the directive principles of state policy under Part 4 of the Constitution. It has been held by Constitution Bench of Supreme Court in Chandrabahan Boarding and Lodging Bangalore versus State of Mysore 1970, that while rights conferred under Part 3 are fundamental, the directives given under Part 4 are fundamental in the governance of the country. This There is no conflict on the whole between the provisions contained in Part 3 and Part 4. They are complementary and supplementary to each other. Article 39A of the Constitution, inserted by the 42nd Amendment Act, has assigned the state to secure the operation of justice in the legal system and provide free legal aid by establishing statutes or such bodies which are necessary for the purpose. Legal aid is a part of right to life. Article 21. As stated by Supreme Court of India in the case of Husainara Khatun versus State of Bihar, that it is the right of every accused person to be represented by a lawyer. If he or she is unable to do so due to poverty, then the state shall provide the person with the required representative. There have been number of instances where the provision of providing free legal aid has been made as mandatory duty of the state and can nowhere be treated as a form of charity. Legal Service Authorities Act 1987. Under Section 2(1) Subclause C of Legal Service Authorities Act 1987, legal service includes the rendering of any service in the conduct of any case or other legal proceedings before any court or other authority or tribunal, and the giving of advice on any legal matter. To provide free and competent legal service to the weaker section of the society was the basic object of enacting the aforesaid Act. Justice, social, economic, and political is our constitutional pledge, enshrined in the preamble of our Constitution. The incorporation of Article 39A in Directive Principles of State Policy in the year 1976 enjoined upon the state to ensure justice based on equal opportunity by providing free legal aid. Our legal system assumes that everyone has an equal right to seek justice. However, legal service often go to the highest bidder. Wealthy individuals and big companies get top-notch advice, leaving the less fortunate at a disadvantage. For a fair society, it is crucial that everyone, regardless of their financial status, has access to the law. Legal aid meant to provide free legal assistance to those who cannot afford it is a noble concept. Unfortunately, it has become a breeding ground for corruption. While free legal aid is beneficial for the poor, it has turned into a practice where lawyers ask for fee once engaged through legal aid. The meager payment to lawyer doesn't convert their expenses, leading to the temptation to ask for additional money from clients. Moreover, the distribution of legal aid cases often seems arbitrary, favoring certain individuals rather than those most in need. This compromises the quality of legal aid and defeats its purpose of ensuring justice for all. India came up with Legal Service Authorities Act 1987, by virtue of which the marginalized sections of the society will be eligible for proper legal aid. The Act is a step forward on the principle of Article 39A of Indian Constitution, which ensures that justice to be provided by equal opportunity. The concept of assigning a legal representative was suggested in 14th Law Commission report. Again, in the year 1970, a committee was set up known as Justice P. N. Bhagwati Committee, which was aimed to create a channel for those who are not being able to reach out to enforce their rights guaranteed by law. This will in turn ensure equal justice and nobody will be denied of justice on the grounds of being poor, illiterate, etc. The Constitution has rightly guarded the concept of legal aid to all the sections of society, and it provides the opportunity of being heard to uphold justice. Article 38 of the Constitution, in its clause, entrusts the state with the duty to promote the welfare of the people by promoting the nation to establish all kind of social justice, economic and political justice. Persons who are entitled to get free legal aid under the Legal Service Authorities Act 1987. Criteria for giving legal service are prescribed under Section 12 of the said Act. Every person who has to file or defend a case shall be entitled to legal service under this Act if that person is a member of a scheduled caste or scheduled tribe, a victim of trafficking in human beings or beggars as referred to in Article 23 of the Constitution, a woman or a child, a person with disability as defined in Section 1, as defined in Clause 1 of Section 2 of Person with Disabilities Act 1995. A person under circumstances to the undeserved want, such as a victim of mass disaster, ethnic violence, caste atrocities, flood, drought, earthquake, or industrial disaster, or an industrial workman, or in custody, including custody in a protective home within the meaning of Clause G of Section 2 of Immoral Trafficking Prevention Act, or in a juvenile home within the meaning of Clause J, Section 2 of the Juvenile Justice Act 1986, or in a psychiatric hospital or psychiatric nursing home within the meaning of Clause G of Section 2 of the Mental Health Act 1987, or in receipt of annual income less than rupees 9,000 or such other higher amount as may be prescribed by the state government. If the case is before a other court than the Supreme Court and less than rupees 12,000 or such other higher amount as may be prescribed by the central government, if the case is before the Supreme Court. Also, there are factors of disentitlement from getting legal aid. Proceedings wholly or partly in respect of defamation or malicious prosecution or any identical proceedings thereto. A person charged with contempt of court proceeding or any incidental proceeding thereto. A person charged with perjury, proceedings relating to an election, proceedings in respect of offences where the fine is imposed is not more than 50 rupees, proceeding in respect of economic offence and offences against social law, such as Protection of Civil Rights Act and Immoral Traffic Prevention Act, unless the case is sought by the victim. Legal aid is also denied where the person seeking legal services is concerned with the proceedings only in representative or official capacity, or if a formal party to the proceeding not materially concerned in the outcome of the proceeding and his interests are likely to be prejudiced on account of the absence of proper representation. In the above two circumstances, even chairman cannot sanction legal aid as a special case. Working of the Legal Service Authorities Act in India. Functions under the Legal Service Authority Act 1987 at different level. Functions of the central authority according to Section 4 of the said Act. The central authority shall perform all or any of the following functions, namely, lays down policy and principles for making legal services available under the provisions of this Act, organize legal aid camps, especially in rural areas, slums, or labor colonies, with the dual purpose of educating the weaker section of the society as to their rights as well as encouraging the settlement of disputes through lok adalats. Encourage the settlement of disputes by way of negotiation, arbitration, and conciliation. Undertake and promote research in field of legal service with the special reference to the need for such services among the poor. Monitor and evaluate implementation of legal aid programs at periodic intervals and provide for independent evaluation of program and scheme implemented in whole or in part by funds provided under this act. Provide grant in aid for specific schemes to various voluntary social institutions and the state and district authorities from out of the amounts placed at its disposal for the implementation of legal services schemes under the provision of this act. Take appropriate measures for spreading legal literacy and legal awareness among the people, and in particular to educate weaker section of society about the rights, benefits, and privileges guaranteed by social welfare legislation and other enactments, as well as administrative programs and measures. Make a special effort to enlist the support of the voluntary social welfare institutions working at grassroots level, particularly among the scheduled castes and scheduled tribes, among the rural and urban labor, and coordinate and monitor the functioning of Supreme Court Legal Service Committee, High Court Legal Service Committee, Taluk Legal Service Committee, and voluntary social service institutions and other legal service organizations, and give general directions for the proper implementations of legal service programs. Under Section 5 of Legal Service Authorities Act, the central authority is required to work in coordination with other agencies. In the discharge of its function under this Act, the central authority shall, whenever appropriate, act in coordination with other governmental and non-governmental agencies, universities, and other engaged in work of promoting the cause of legal service to the poor. Function of the state authority. Under Section 7 of the said Act, the function of the state authority are prescribed, which are as follows. It shall be the duty of the state authority to give effect to the policy and directions of the central authority without prejudice to the generality of the functions referred to in Surplus 1. The state authority shall perform all or any of the following functions, namely, give legal advice to persons who satisfy the criteria laid down under this Act, conduct, undertake preventive and strategic legal programs and perform such others. Under Section 8 of the said Act, the state authority is required to act in accordance in coordination with other agencies and be subject to the direction given by the central authority. In discharge of its function, the state authority shall appropriately act in coordination with other governmental agencies, non-governmental voluntary social services institutions, universities, and other bodies engaged in the work of promoting the cause of legal service to the poor, and shall also be guided by such directions as the central authority may give to it in writing. Function of district authorities. Under Section 10 of the Act, function of the district authorities are: it shall be the duty of every district authority to perform such of the functions of the state authority in the district as may be delegated to it from time to time by state authority, without prejudice to the generality of the functions referred to in Surplus 1. The district authority may perform all or any of the following functions, namely, coordinate the activities of Taluk Legal Service Committee and other legal services in the district, organize Lok Adalat within the district, and perform such other function as the state authority may fix by regulations. Under Section 11 of the said Act, the district authority is required to act in coordination with other agencies and be subject to directions given by the central authorities, etc. In the discharge of its functions under this Act, the district authority shall, wherever appropriate, act in coordination with other governmental and non-governmental institutions, universities, and other engaged in the work of promoting the cause of legal service to the poor, and shall also be guided by such directions as the central authority or the state authority may give to it in writing. How to get free legal aid in India? A person who qualifies the eligibility criteria as in Section 12 of Legal Service Authorities Act may approach the appropriate body constituted under the Act to get free legal aid. National Legal Service Authority Regulations 2010 consist of various regulations: Supreme Court Legal Service Committee, State Legal Service Authority, High Court Legal Service Committee, District Legal Service Authorities, and Taluk Legal Service Committees in India must abide by. An application to be filed by the applicant and shall be preferably represented in the Form 1 represent at the end of the regulation. Such an application shall be filed along with the summary of the grievance for which the applicant seek legal aid. The form may be filled in local language or English. Oral requests may also be entertained, similar to an application under Form 1. The applicant shall attach an affidavit stating that the appellant qualifies the eligibility criteria as specified in Section 12 of the Legal Service Authorities Act. Application forms are additionally represent at all the said bodies free of expenses. After receipt of application, the Board of Trustees set up by the functions where such application has been recorded will investigate the application to set up whether the candidate is qualified for free legal aid and shall revert within 8 weeks from the date of the receipt of such application. Legal aid clinics. All district legal service authorities are required to establish legal aid clinics in villages or cluster of villages depending upon the size of the village to provide legal aid to individual, particularly where there is land, social and different boundaries to access the legal service institutions. However, it is subjected to the financial resources accessible to the district. Legal service clinics in law universities college. Usually every law university college set up as part of legal education by section 4 clause A of the Legal Service Authorities Act. Legal services clinic to give a lawful guide to the neighborhood individuals free of expenses. Such legal aid clinics might be drawn closer to get free legal service. Non-governmental organizations. Various NGOs give free lawful counsel to individuals concerning the field they work in and help them in getting legal aid, either their own or those gave by the state law firms, lawyers, etc. Thank you so much.